Okay, today I want to kind of check in with you and I guess do two things. The first thing will be to kind of just give you a very realistic picture of what I'm dealing with, to give you a little bit clearer expectations of what you should be doing and what you should be expecting of me. Um, and then secondly, I want to do a midterm review. Now, the midterm is not going to be until April 20th. It'll be open for 2 days. It's online. Um, but I wanted to give you enough time to kind of prep for it and then encourage some of you to do the work. So I might just start with that. So out of 140, let's see, 123 students, um, 85 of you have been able to get the book. So I need to try to find out some additional resources for the people who are unable to get the book so they can prepare for the midterm. And I'm going to be doing some of that today, and then I will be sharing those resources for you over Blackboard and on the course website. The second, probably more urgent issue is that about 40 of you have got up to the reading quiz 2. So that's 80 students who have not kept up with the work, right? So like I said a week ago, which might seem like much longer, but it was only a week ago, and I said I needed 10 days to kind of get caught up. I'm 3 days ahead, so I might just put it in perspective is that, I have to respond to the reality of what students are able to do, not based on wishful thinking, but based on what I'm actually seeing on Blackboard and on Google Forms. So I'll start off with the positive is that most of you, the majority of students per class, right? So there's 3 classes that are doing this work. The majority of each of you in those classes are doing the work at about the same rate in my experience have been done in the classroom in an ordinary time. The difficulty, of course, is for the same number of students who are struggling, it's just harder to get access to you. So some of you I haven't heard from yet. I need to hear from you. The second thing is maybe on a more negative note, some folks have been quite disrespectful in their emails. And so I want to just reiterate that I will not tolerate it and that I will be forwarding your information to the appropriate people on the campus to deal with it. Like I said, with over 150 students in 4 classes, I just can't deal with that. So please, 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 before you send a frantic email to me, if you're having a stressful day, like I keep saying, take 2 deep breaths, remain calm, and then very politely let me know how I can help you. But other than that, let's just try to do the work the best we can. And again, if you've forgotten a bunch of things, which some of you seem to have forgotten, go back to that introductory video that I gave you last week and remind yourself that these assignments are pass-fail. Okay, that the first real assignment is going to be the midterm, and that we'll see how we're all doing, and that I will be basing the rest of the semester based on how people do in that work. Like I said in the video presentation, I will work on a way to do a Zoom conference with you. We're getting more instructions about that tomorrow from the campus. You may not be aware that we're technically not even supposed to be working right now. This is a pause period to let you all kind of catch up and figure out how you can get access to the internet, to computers. And Kingsborough is supposed to be providing that to you, and the City University of New York is supposed to be providing that to you. And then we're all having, in our department, are having a meeting tomorrow online to let us know what the school is doing. I will keep working. Obviously, I'm working today. I'll keep working and keep making videos, keep making assignments, keep making surveys, right? Keeping anything I can do, giving you additional resources if you can't get the book to help you get through this time. But I think you just need to remember this is an unusual time. And a lot of the things that would work, and I mean like agencies, offices, right, services that would be available in an ordinary time are not really working all that well right now. So again, just please be patient. You're not going to be punished. I give you the due dates are not harsh due dates. I've said that I think 100 times, but I'll say it one more time. I'll accept late work. I haven't even closed the first 4 assignments yet because so many people needed to still do them. I do need to just let everybody know that means that it's going to take me longer to get you feedback if other students aren't filling out the first assignments. So this is kind of the difficulty is with 120 students, only about 30 students are caught up. So that's 90 students that I have to spend time with to catch up. So if you're ahead, you're going to have to take a little break, which is why I put the midterm April 20th. So you'll have time to focus on your other classes, and then you can kind of break down what you need to do specifically to prepare for the midterm. So getting to the midterm, this should be something you should take notes right now, like you would if this was a lecture or presentation in class, because I'm going to go over a lot of details, and then I'm going to provide a lot of resources across the Blackboard and across the website. So many of you have asked about this second website, so here it is. Take a picture with your phone, write it down, type it up, and at the end there of the URL, the address, it says Section 1. So if you look at the book and you see Section 1, there are additional resources on this website for Section 1. On the left-hand corner, there's tabs that take you to Section 2, Section 3. So there's additional resources. Again, these are not required, but I anticipate they will help you. And if you don't have the book, this will at least give you some information until I can get you more resources, which is harder than you think it is, I think, for many of you. So I just want to remind you of this website, and this is where you can go to kind of get deeper into the issues and better understand. And then I'm going to present everything in the same order that I asked you to do it. So we're going to start with constitutional interpretation. So there's 2 videos that you can watch. One is from the former Justice Antonin Scalia, who is a large influence over the way lawyers, judges, and law school students interpret the United States Constitution. Another big influencer is Thurgood Marshall, Justice Ginsburg, and we'll go kind of through these different interpretations. But the majority view of how to interpret courts and the Constitution is Scalia's variation or his version of something called originalism. And so you need to kind of just, in the simplest terms, understand that originalism says that we should interpret the Constitution the same way it was interpreted in 1789. There are obvious problems with doing that. The first one is, well, whose interpretation? Not everybody interpreted the Constitution the same way in 1789. And so one you need to just kind of understand immediately was, well, who gets to be included in the democracy or in the republic, in the democratic republic? And at that time, you might recall that it was English and a handful of Scottish individuals who owned large amounts of land, and you had to own a certain amount of land, and you had to be, if not educated, at least smart enough to advocate for yourself politically. And so it's a very small number of people that the Constitution applied to. So in other words, 90% of the human population in 1789 did not get the benefits of the United States Constitution. This is what Scalia is saying, and this is what originalists are saying, that the first beneficiaries of the Constitution should go to that first group. So it's easy to label this as a supremacist point of view. Before many of you start saying, I think this is a great way to interpret the Constitution, you would not be included in that interpretation of the Constitution. So you need to kind of think about that for a second. There are ways in which originalists would allow folks to benefit from the Constitution, but that would come through representation. So if you're not voting, then you certainly wouldn't be involved in the beneficiaries. If we contrast this to Raven-Symone's point of view, this is a pluralist or a multicultural point of view, saying that, well, everyone should be included in the United States Constitution, the beneficiaries of it, because of its promises of due process, because of its promises of equality, and so on. But again, there's no rule saying that you must interpret it one way or the other, so it's a choice that people make. So I'm asking you to consider for the midterm, well, what is the problem of interpretation? I'm answering it for you here. is that divided justice in the United States, the law is supposed to be supreme across the country. But if people interpret it differently and give benefits to different groups and then exclude other groups, then that's not really united, right? That's very divided. And that's the reality of the situation we live in. So we might want the interpretation of the United States Constitution to be ideal. We might want it to be a certain way. We might think it should be a certain way. We might argue it should be that way. But in reality, that is not what happens, right? Groups interpret the Constitution to benefit their groups. And that's something that you need to understand from that first section. Once you get just kind of that clear kind of distinction, there's more than two points of view, but the main, groups are the pluralists versus the originalists. So then we want to apply that. We want to apply legal reasoning and see how does this work in the real world. So it depends, right? You would pick an interpretation here. You'd take an originalist interpretation or the pluralist interpretation, maybe switch it up, right? Do it one and then do the other. And then you apply it to the case, Miller versus California. Now, I'll provide a link to the full case. So for those of you who don't have the book, you can read the full case. In the book, we, just give you a section of the case, and you'll see the reasoning, and that's what I'm really hoping that you'll start thinking about is what's the reasoning within constitutional law? How do they justify their answers? So, you'll then take that reasoning or that ruling, that decision that the court makes about what they consider to be obscene, how they think that should not be covered under the First Amendment, which is a huge deal, right? You can see that's very much an originalist point of view. A pluralist point of view would say that, that's free speech. And then you'll look at Mapplethorpe's art, and I have a link that you can look at the exhibition that he got labeled as being obscene. And you can make your own decisions, right? How would you approach that? But the point being is that you look at, okay, under an originalist interpretation, only like a Puritan point of view would be covered because those are the people who wrote the rules of the Constitution. But should that be the case today, right, in 2020? So, I think if you look at Kim Kardashian, in 1787, she would be in jail, possibly burned, but at the very least criminalized, right, for obscene behavior. In 2020, and this one I think is actually 2010, or 2014, society does not consider her to be obscene, or at least they don't consider her to be criminally obscene. I'd also say that, like the picture above, like this is Two Live Crew was considered to be obscene, right, in the 80s and 90s. But now that is, obviously not the case. I think just watching South Park would be a great example of how, social values or norms have changed as to what most people believe is obscene and what is not. However, the Supreme Court decision still stands. So people could still technically get in trouble or be in criminal proceedings because of their behavior. So you want to think about something like very concrete here. Interpretation changes the outcome of the case. In a pluralist interpretation, we have situations like Kim Kardashian, Two Live Crew, right? Things that you might not think are moral behavior, but nonetheless, right, they're not criminals because of it. Versus the originalist position, these would be criminals, right? They would be in jail. So then I need you to make sense of that. Like, how do you make sense of this? What does this say about your identity? What does it say about how you fit within the constitutional legal structure? What does it say about how you would interpret the Constitution? Then we want to move from making sense, right, having an opinion, having a subjective point of view, to thinking about other people's points of view. And this is critical thinking, right? So we want to look at agency. So maybe it doesn't affect you, right? But if it affects, people in the United States, then we can't have a fair system unless everybody has fair access to the courts. And so we want to think of this, overwhelming ideology within the United States called individual responsibility. The problem with that myth is there's no such thing, right? There's no such thing as individual responsibility. It's just like a platitude or a saying that people, just tell other people, right, when they want them to do something. So there's a book that comes from the college that I went to, and it's a well-known book. Lots of political scientists should know about this. If they don't, they should. And it's called The Politics of Rights, but it talks about the myth of rights, right? That rights are not automatic. You have to demand them. So they don't just exist in the world and you get them, right? So you usually will have your rights violated by some other person, and then it assumes that you have enough knowledge about the system and about the rules and about your identity to kind of be an agent of change in your own life. The hard part, of course, is that you have to see this from multiple points of view, not just as you're getting your rights taken away, but in reality, you'd have to see this ahead of time. So the best case that I think, in the United States history that goes back to like the interpretation plus agency is Scott versus Sanford. And there's a video on that website that I talked about. There's the text of the Supreme Court decision in the reader, and you can also look this case up, or I'll provide the link to the full case. Again, like the Supreme Court decided that you could not be a citizen of the United States unless you were intended to be a citizen of the United States under the interpretation of 1787. And so, because Africans were deemed slaves and not citizens, then the court applied an originalist point of view in interpretation and said that because of that, you can't be a citizen in the 1860s. You can see that under a pluralist point of view, that they would have said, if you live here in the United States, you pay your taxes, you're willing to join the military, you have a company, obviously then you'd get to be a citizen. So you have two very different ways of interpreting the Constitution. But, the law on the land of this time, the Supreme Court case has never been overturned by another Supreme Court. So it really kind of defines who gets to be a citizen very narrowly under the originalist interpretation of who got to be a citizen in 1787. So this would obviously eliminate women, for example. This should highlight the problem of federalism, what is also called new federalism, supremacy in the economics of slavery. So you'll notice there's a striking contrast between the red and the blue states, and then these kind of purple and greenish kind of states, right? Is that red states tend to follow an originalist interpretation of the Constitution. Blue states tend to follow pluralist, right? We live here in New York City. It's much more of a pluralist interpretation of the Constitution. But you could just go to Staten Island, and it's a much more originalist interpretation. And so these interpretations are constantly in clash with each other. And so when you have 50 states, you really have 50 different ways of seeing the Constitution. And that's not a united point of view. You're seeing this in the response to the coronavirus right now and how people believe that they should behave. So the red states tend to talk about individual responsibility. By the way, they seem to be having the most problems with, getting people to actually follow the rules. Whereas the blue states talk about kind of collective or social responsibility. And in those cities have much larger populations. And so it would be pretty crazy if they said, well, everybody just has to fend for themselves. Smaller states can probably get away with the myth of rights because most folks don't really utilize the government. However, in a pandemic and a healthcare crisis, you see that suddenly, even those people suddenly need the help of the federal government. So we want to remember this is all a part of the legacy of white supremacy and the economics of slavery, that the originalist position was to protect private property and the right to own slaves. The pluralist position is the one that says we're all equal. And so there's two different, points of view competing with each other about how society should be organized and what law should be used for. So what I'd like you to do, after this presentation is to go on to and this is just a practice thing, so you don't need to get stressed about this, but you go to the Kingsborough Library website, have your ID ready, enter it in the box there, and then you're going to go to the search engine called JSTOR, and I'd like you to get a book review or an article or something about The Clash of Civilizations by Samuel Huntington. He's taking a very originalist point of view about how different countries see identity and how they see change. And so I want you to see that, since Huntington wrote this article or wrote this book, there have been dozens of updated articles that disagree with it, that provide different evidence, and that many of his predictions in the book did not turn out to be correct. Some of them did, some of them did not. But a lot of folks use what he said about the United States being a split or a torn country in between Spanish-speaking people and English-speaking people as a reason to argue for an originalist position. Whereas you can see a pluralist position would say, the more languages a country speaks, the better, right? Something like Switzerland. So you kind of have two different visions of how you would see both society and how conflicts would get resolved. So I'm asking you to really consider this question as you see all these different points of view about something like, well, what is culture? What is identity? What is citizenship? Is to think about how does this interpretation of the science of politics frame conflict within the U.S. and the global political order. In other words, is the way that we're talking about this setting up a conflict that will be more difficult to resolve? And if so, is there some way that the law can speak to these things, right? Can we use the law? Can we use courts? Can we use the Constitution to try to resolve this conflict? Now, if you think this is like just way too idealistic, you might be right. However, if you read the preamble of the Constitution, the very beginning of it, it says it's been written in order to form a more perfect union. So the idea is they're trying to resolve these conflicts of difference. And the Federalist Papers were written largely about talking about how do you resolve these different personalities, these different perspectives, these different ideologies. So we just want to think about not just 1787, but we want to think about 2020. And given the fact that we live in a global migrating and changing environment, right, where people are coming and going, it's much harder to put somebody in one box as their identity. And so what does this say about how we're going to advocate for law in the 21st century? So moving away from identity, we want to move towards agency. So we want to start to see the structures of law, the court system, the Constitution as something that gives rights, but then also protects you against the abuse of power. So we want to look at it from the kind of a very clear point of view, which is Dr. Martin Luther King Jr. and his letter from the Birmingham jail. And so I need you to understand that in addition to being an advocate for the civil rights movement, for being a preacher, he was also a political philosopher. So he was building on work that you could learn more about in other philosophy and political science classes on Aristotle, St. Augustine, Malthus, Hegel, and Niebuhr, where he was arguing for collective action. So he was saying how he was studying when do things change, either for the better or for the worse, and how do social groups kind of organize and advocate for their position. So the main points in the letter from jail, right, is he's saying like, well, you'll often hear the status quo, right? The majority population will often say, well, why don't you just wait and eventually, we'll be equal. And his point is, well, African Americans have waited for 200 plus years. So when is this change supposed to happen? And so he says, according to his study, right, Augustine, Aristotle, Hegel, you have to demand rights. People don't just give you things. So if you think that your rights or your dignity or your personal property or any of these things that you believe are important have been taken away from you, you must work with other people to bring this attention, right? And he really specifically talks about that word tension, right? So he says there's going to be conflict. And so this is how we resolve conflict, is through the language of rights. So we want to think about, like, how does this idea of democratic participation use the originalist interpretation to construct a form of practical resistance? In other words, instead of just saying, like, oh, I wish we lived in a pluralist society, King says, well, the reality is that people are trying to exclude different groups from society, right? People are trying to put people in prison. People are labeling inappropriately. People are wrongfully convicting other people, right? So instead of just pretending like that doesn't happen, he argues that you need to set up 2 points, right? One says, these are the people who want to exclude. Here are the people who want to include. And so justice can only be the process of bringing everybody under the same law. And so if people are being excluded from access to the law, then you don't really live in a democratic society. So 2 kind of people who have picked up this legacy have been Angela Davis and then also Michelle Alexander. So they've been talking about how the exclusion of justice or the threat to liberty means that there's no justice, right? You can't have justice for some people and injustice for others. So the ideal of justice is that everyone, right, would have access to the courts. Everyone would have rights and no one would be excluded. The reality is that social groups like white supremacists use the law against other people. And so the goal here of these theorists was to say, well, how can people who are being targeted use the law against those same people to restrict the abuse of power? So one person who really was successful in articulating this resistance, this law as resistance, was Thurgood Marshall. And he did this both as a lawyer when he was doing litigation in the Brown versus Board of Education cases, and he did that in 13 plus cases across the states. And so he saw this as a much bigger issue than just one conflict. But he had this big question. He wanted his legal team and the civil rights advocates that he's working with to think about. How do you prove that segregation and supremacy harms minorities? You can say it like hurts somebody's feelings. You can say that it excludes you from drinking out of a water fountain. But how do we show that there's actually long-term consequences of this? So on that website that I talked about, Imagine One Commons, ImagineOneCivic.commons, sorry, you see the doll studies, and that's what they brought in was social science to show in court how exclusion, how segregation, how supremacy, how hatred affects society, multiple generations. And so what kind of interpretation is this? It's not exactly a pluralist point of view, right? Because it's using that same kind of structure that King, Angela Davis, and Michelle Alexander are saying, right? So you set up on one side, you say, okay, this is the reality. Some people are going to be, bigoted, they're going to be prejudiced, and they're going to use the law to try to punish other people. So then that group that's being targeted must use the law, that same law, to throw it back at them and show that this is injustice. So this point of view by Thurgood Marshall and also James Brennan was looking at, well, what about the people who are watching this, right? What about that status quo group I was talking about, that majority? Will this change the way they think about things? Once we start saying this is justice, this is injustice, right? People then are forced to start reconsidering their own identity and what they would like to see and what they think is equal. So this is a different type of democratic participation. This is one in which says, well, it's not enough just to vote for a representative who's going to then pass laws for you, right? This is not a form of democratic participation that says you should just always follow the law even if it's bad for you. What it's saying is that everyone should get to participate in making the law. Now, that's a very difficult thing to do, but one place where it has been successfully done is in legal education. So more people from different backgrounds have participated as lawyers, judges, and justices over the last 200 years than just about any other field. And so you can kind of see that you could structure education in such a way that people would know their rights, right? That they'd advocate for their rights and they'd speak in such a way. So when Justice Marshall and Justice Brennan joined the Supreme Court at the same time, they both saw that this is one way that they could kind of advocate for people's civil liberty. And civil liberty was not about personal liberty. It was not about individual responsibility. It was about how can we encourage you to participate in a democratic society in a way that kind of constructs knowledge for everyone and that improves the situation for everyone. So it's much less individualistic, and it's a retreat I would say, the opposite point of view as the originalists. It's not quite a pluralist position. It's a little further than pluralism, because pluralism, you'd still have like a representative of your group, right? So that's just a division of groups. This is saying like you really need to bring everybody together, right, and have them decide what justice is going to be for everyone so that no one is excluded. Now, some people might say, well, this is impossible, and you might be thinking that. It's not, right? There's been several instances in which this has worked, but you are correct, and there's been more instances in which it's not. But I would argue that's because there are more people who are bigoted and prejudiced than there are people who are not. So you're really just talking about trying to change people's minds over a long period of time. And this is, if you look at the 14th Amendment, coming 100 years after the original Constitution, and now over 150 years ago, you can see that as like the midpoint, right? And that comes after the Civil War. It comes after the Scott versus Sanford case. You kind of see this like building up of tension, the two sides, one that wants to exclude people, the other one that wants to include people, coming to war. And so they had to fight a war together or against each other to decide which ideology was going to win out. Now, that one won out in the law, right? It won out in the process of passing this amendment, the 14th Amendment. But those people who still wanted to exclude, right, they created a new federalism. They created what Michelle Alexander calls the new Jim Crow laws, right? So they continued to exclude people in violation of the Constitution. So I think that's a hard thing a lot of students didn't quite know before they got here, is that lots of states, lots of corporations, lots of people violate the Constitution every day. So they pass laws, they pass rules that are in violation of the Constitution. And that's a large number of cases that the Supreme Court deals with, is looking at, this is called judicial review. So when a state or when a locality or when a corporation violates the Constitution, people have to bring a lawsuit. So there's lots of people who get their rights violated who never bring lawsuits. Maybe you have, right? And so if you don't bring a lawsuit, then the Supreme Court cannot declare something to be unconstitutional. But under the 14th Amendment, the standard, right, comes from something called natural law, which is a much older kind of law, and it goes to natural philosophy. But he's saying that there are rights that could never be taken away from you. Somehow in the United States, human dignity has not been defined as that right. In one case, Texas versus Lawrence, Justice Kennedy comes very close and uses the language of human dignity, but it does not get full protection. So you kind of famously remember that's the right to liberty, the right to property, and the right to pursue happiness. That one seems to be the most vague, right? But this all comes under two forms of the 14th Amendment. The first is procedural fairness, that you have access to courts, that it's a speedy trial, that you have access to a lawyer, and then that there's a subject protection. So your rights by law cannot be violated in relationship to your religion, to your creed, to your motto, to the way your philosophy, to your race, to your ethnicity, to your national origin, and you could extend this to like language, etc. Now you can see that like Donald Trump's travel ban, right, has threatened the 14th Amendment, and that's why there's lawsuits right now that are circulating, and the Supreme Court has ruled only on one part of that ban, and has not quite taken up this whole bigger question. So this leans towards privacy and individual liberty. So you see, like, due process doesn't quite get as far as Thurgood Marshall and Justice Brennan had wanted. It's moving from an individual or an originalist point of view to a pluralist point of view, but it's really saying that you have privacy and liberty within your identified group, whether that's race, which is a social construct, right? Whether that's national origin, and countries change all the time. So these aren't quite as firm as folks might have wanted when they passed the amendment. I might just compare this real quick to positive law. That's what most of you seem to think the law is, right? It's like if the government passes a law, that's a rule. That form of thinking largely comes out of Germany, and to be really blunt, it comes from the Nazi Party in 1930s. And you sometimes hear, people say this even today. They said, well, if only we had like the government of China, where they could just violate people's civil rights, we'd be able to do things very differently. Sure, right? I mean, that's true, but your rights would get violated every day. So it's a balance that, you have to decide on your own what you think is more important. Would you rather live in a dictatorship? Would you rather live in a monarchy? Would you rather live in a republic? Would you rather live in a democracy? Or would you rather live in like this blended system we have in the United States, which has a lot of problems, but it has problems that people get to participate and argue about. So getting to the balancing idea is Planned Parenthood versus Casey, and this came from Justice Sandra Day O'Connor. And she really articulated this idea that, well, we don't have to have just an originalist interpretation and a pluralist interpretation. There must be some third way. And she called this the balancing test. So in reproductive rights, she said, well, we shouldn't just focus on the right to privacy. Obviously, you have a right to privacy. But we also shouldn't just focus on reproduction as a state interest, right? The government actually obviously has an interest in how many citizens it has, whether people pay taxes, et cetera. The moral interest of the state, all these things are important. But she says, you don't have a right to interfere, right? And that's where she says you can't, have an undue burden, right? So if you're interfering in someone's life, as far as their health, their privacy, and their reproductive rights, there has to be some valid government interest that outweighs that person's individual rights. And so what she does is she creates what's called the third way. And the third way here is trying to create a balance between the pluralist rights, right, the right that you can do what you want based on your culture, and then the right of the originalists, which say, well, this is the structure we designed, and so we want everybody to conform to that structure. And so she's really trying to balance this. She does this again in later in a terrorism case, where she says she agrees that the security threat posed by terrorists is important, but at the same time, we need to be a model for the rest of the world of letting people have access to courts. We can't violate due process in the 14th Amendment simply because it's dangerous, right? So she argues for a third way is there as well. The two principles that are in the 14th Amendment and this balancing test are that whatever the action is, it can't be arbitrary, it can't be random, it can't be accidental, and it can't be capricious. I mean, it can't single you out, it can't be focused on your religion, it can't be focused on your national origin, it can't be focused on what language you speak. So the balancing test is all about saying, like, okay, if there's a valid interest of the government, then they have to say what that is clearly, and if it violates somebody's protected rights, then it's going to be deemed unconstitutional, and it's not going to be balanced. So then that kind of just brings us to this last part of this before the midterm, which is Patricia Collins talks about self-definition as a power of resistance to domination, control, and supremacy. This is bringing us much closer to the concept of human dignity, which is a universal human right. It's in the EU Constitution, it's in the South African Constitution, it's in the Indian Constitution, it's in the Brazil Constitution, it's in the Ireland Constitution. It's a form of protection in the British government, but in the United States, we have not yet committed to human dignity being a protected right. So this is because if you set up these, we're expanding the ideas here. So if you set up this idea that Patricia Collins says is that, when you respond to someone labeling you, that's a power that you might not have known you had. And that changes not just yourself, but it changes the environment as well. Compare this to kind of the structure we all live in, which is this idea of liberal democracy that goes back several hundred years, which is this balancing act of autonomy, security, which is the security of private property and economics. So sometimes people think, national security. Well, that's not national security to protect you, and that should be obvious in this pandemic. They want to protect the economy, they want to protect the richest folks, and they want to protect private property, so large buildings, corporate buildings, right, things like that. It's not about your security. People seem to get that very confused in criminal justice classes. You might want it to be that way, and that would be fine, but that is not a principle of liberal democracy. That is a principle of a dictatorship. What you might mean is welfare, right? And that's the public interest. And here we don't mean like cash payments to people. We mean like looking out for the public interest. So right now, they're doing the tax cut rebate $1,200 thing for the public interest, right? It's supposed to keep the economy circulating, give money for people who might be out of a job. This is kind of to protect private property. So you kind of see this, how welfare works out. And then participation in steps. So, liberal democracy is, like I said, first and foremost was about English, upper middle class folks who had property, that they get to participate in government. That then expanded to their wives. It expanded to immigrants, new immigrant groups. Then it expanded to African Americans, and then it expanded to younger people, right? The voting age used to be 21, for example. So it's like a step by step of who gets to participate, but it's not trying to let everyone participate in the system. Patricia Collins is arguing that, by using self-definition, right, by resistance, by articulating what you would want to see in the world or what you want to see in America, that expands who gets to participate. So again, human dignity would exist when everyone gets to participate and when no one is being arbitrarily or capriciously excluded. So in review, right, this is kind of everything so far, is I need you just to remember, right, these basic points. So law is a tool for groups. Okay, so it's not just about obeying, it's not just complying, it's not just resisting. It's also, we use these laws, we use these interpretations differently. And that's because we have different goals, right? Some people are more interested in money. Some people are more interested in happiness. Some people are more interested in liberty, right? So they're going to use law differently based on what their goals are. So the definition of justice depends on what group you're in. If you identify with a group that's been systematically excluded for 200 years, then inclusion would be justice. If you have benefited from privilege and you benefit from not really having to work too hard because things are mostly given to you, then justice might be a little harder to imagine because you seem to have things going your way. If you come from a different society or a different country, justice might mean something very different there than what it means here. So you can kind of see that different goals in different groups kind of define justice differently. So you need to think there is obviously the power of domination, and I'll call that power one or law one. And that's, the power over other people. But there's also the power of resistance, and people resist all the time. They fight back, they use lawsuits, right? They change the law. And this is what we mean by law as social change. So then we also have this bigger picture of the separation of powers. We have conflict and divided justice. These are kind of, the results of these different opinions. And then we want to apply this to minority groups. We can't always just look at law as how it applies to the majority population. We need to see, well, what happens to those people who are excluded? Felons, for example, right? They don't have the right to vote. And yet every 4 years, we say, everybody should vote, everybody should vote. And then people forget, oh, but you can't vote, right? Or undocumented immigrants, they say, oh, everybody should vote, everybody should vote. But then they forget that person can't vote. So we have to think about how does this use of law as domination and resistance affect people who don't even get to participate in the game at all. Then that should really come down to your identity. So what is your point of view? And I really want you to start thinking about what is your ideal point of view? What would you like to be seen as? And then what is the reality of that situation? How are you mostly seen by the majority population? How are you seen by police? How are you seen by court justices? How are you seen by politicians? And then this leads us to get to agency, which is, well, once you understand your identity within this constitutional Republican system, how can you self-define yourself plus act within this structure? So how can you learn the rules? How can you use the law? How can you work with other people? And then these last three ideas is kind of a preview. So you don't need to understand this thoroughly, but you just kind of remember these three words: institution, ideologies, and instrumentalities. So the institution of law is like courts, right? It's the location. So it's lawsuits, it's congressional legislation, and the courts as an interpreter. So we look at judicial cases, which you've done. You looked at Miller versus California, you looked at Scott versus Sanford, and you looked at Brown versus Board and Planned Parenthood versus Casey. And so you see this is the institution of law. This is the law as a place, as a venue. Then there's the ideologies of law, and like you'll remember, these are in conflict. These are interpretations that are not in agreement with each other. They're divided. So you have the ideology of supremacy, you have the ideology of pluralism, you have the ideology of participation, and you have the ideology of representation, just to give you four to start with. And so these are all very different ways of seeing how the law should work and seeing how the law does work. And then finally, we have the instrumentalities of law. So that's what you kind of think of power, right? That's influence, that's participation, that's learning, and that's advocacy. And so this is how people use the law as a tool. So we have the institution, the place, the mental model, the way people think about the law, and then we have how they use the law. So when you put those things together, you start to see, hopefully this is almost like a game, and then that there are people who are not participating and they're losing simply by not participating. And then there's other people who are purposely excluded and have to figure out somehow how to get into the game, how to advocate, how to convince other people, and so on. And so that's all I'm trying to get you to see so far. So it's not a lot of content. It's mostly just a point of view. I'm trying to get you to understand the rules of this game of constitutional law before we start getting into more details. And so that's what we're going to be focusing on in the midterm. And then I just want you to remember, we are in the middle of a very intense election year. And so far the polls are showing, Donald Trump and Joe Biden are like 50-50. So this is an interesting time to be in this class. So I've been collecting some of the news clips from the week to talk about some of the constitutional issues. And so I'll be working on that over this week while you're studying. And so after the midterm, I will have extra credit assignments. I will have preparation for your paper, which again is not a research paper. It's more of a, how are you going to apply what you've learned so far? So you can't think about that paper until after the midterm, because first you have to understand the midterm. So please do not ask me about the paper until after the midterm. And guess what? You won't have to ask me, because I'll tell you right after the midterm. You'll have lots of videos, lots of resources, and lots of extra work to help you out with this process. So again, just to remind you, midterm. So if you haven't done all the work, right, you've got 3 weeks to do it. So pace yourself, right? Take your time. I'm going to continue collecting your information, and just for those of you who are behind, I might send you an email saying, you got 2 weeks kind of thing. For those of you who are ahead, great, right? Take your time, focus on your other classes. And then I will be coming out with more resources for you over the next few days. Okay, so stay in there, right? Hang in there. Most of you are doing well. Well enough, I should say, right? Most of you are doing something, and that's the goal right now. This is tough. We've only been at it for a week, so try not to get too stressed out, right? This is something we all have to adapt to. And again, if you need me, I'm here, and I'll keep working on as many resources as I can.